Martha, how you doing?
Good, good. I'm excited.
Excited about this?
Yeah.
I am too. So what we're going to cover right now is the contract. It's a state contract done by the Arizona Association of Realtors, the General Counsel. They draft all these state documents so that they are templated to some degree. But there's some issues in here that are very important that we're going to cover. We talked about the 3 contingencies that you will have throughout the process of offering on a property, so we're going to cover those in here, which is very important. But if you don't mind, we'll just go down line on here and go through it and hit the highlights.
Sure.
Okay? So this is your name right here, you're the buyer. The seller, their name is left blank here. You can fill it in, but also too, this covers that. Identified in section 9C, which you'll see in the back of the contract. You have the address here, okay? And you have the legal tax ID number. And now, regarding the price, this is section 8, okay? Or line 8, excuse me. The price. Now, we talked about you'd be offering $500,000 for this property, right? We figured that was a pretty aggressive way to come in, try to get a good deal on this house.
Yep.
Okay, awesome. So that's there. And then the earnest deposit. Typically, the earnest deposit in the state of Arizona is 1%. That's what's standard. So in this case, it'd be $5,000 you put down as your earnest. Now, we can go a little lower if you like, but we also could go higher than 1% too. From my opinion, I always think because it's completely refundable. No questions asked for the first 10 days after this contract is accepted. So if we're trying to get a good deal in this house, which we are, a lot of times I like to advise my clients to come in higher on that 1%. Because whether it's $1,000 or $100,000 on the earnest money, it's still refundable, but yet it gives you leverage to maybe get a better deal in the price.
When does it become non-refundable?
After well, you got 3 contingencies, so we'll cover that here, so I don't want to get ahead of myself too much, but after the 10-day home inspection period is up, it does for that. But then you also have 2 more contingencies that will last throughout the escrow process up to 3 days from the closing date, actually, which is very buyer-friendly.
Okay, because I just don't want to lose that money.
Well, that's my #1 job. So my #1 job and the team's #1 job is to make sure that at all times that money is protected.
Okay.
And we will double check, triple check those deadlines at all times to make sure that we are within the contractual guidelines, so that's always protected.
Okay.
#1 job.
All right.
Okay. And then you're getting conventional financing with 20% down. So the down payment's right here.
What if that changes?
The
like
down
if
payment.
I've talked with my lender and there's a couple options he's presenting to me. What if that changes? Does that mean I have to notify the seller?
Not one bit.
Okay,
No,
that's
not
good.
unless it affects the closing date. Okay, you can switch whatever you want to without their permission as long as it doesn't affect or damage them in any form or fashion, which is the most common breach is the closing date.
So if I want to put down more cash?
Yeah.
Okay.
Absolutely.
All right.
Absolutely. Now we have to notify them.
We do?
We do.
Why?
Because there's a section here called changes, okay? So any changes, we have to notify them, but they can't stop you from doing it. You don't have to agree with it as long as you still close on the same date we initially agreed to.
Okay.
Does that make sense?
Yeah.
Okay. Awesome. So then 20% down right here, that leaves your amount that you're getting by your new conventional loan right here. Okay, that's the difference. Now, close of escrow, okay? We decided on this day, March 12th, okay? That gives you a little over 30 days, which should be sufficient, according to your lender, to get this done.
Right.
Plenty of time.
Said.
Yep.
Okay.
So we're going to go off him. That's his area of expertise on that. So now, this says right here that the buyer shall deliver the escrow company a cashier's check, okay, or wired funds, or potentially a personal check that will go and be held by them, okay, during the escrow period, and that earnest deposit check will also be credited towards your down payment at closing, okay?
Do I need to write that now?
You do.
Okay.
Yeah, I need to hold on to that to make sure I tell the seller or represent the seller that I have it ready to go if they decide to accept it.
Okay.
Okay? And this right here says possession. Possession means that seller has to deliver the property to you so that you can close at the close of escrow. Now we can change that, but that'd be kind of for something very specific that we're not going to do. We just want to get the property when we say we want to close on it.
Okay.
Okay. Addendum incorporated. So these are all the addendas that you could have in the property. We do have an HOA. So there's HOA addendum that you'll see, as well as a market conditions advisory addendum, which is a pretty. I basically call this I graduated 3rd grade document because it's ridiculous. But you'll see what I mean. It's cyclical. It's ridiculous. But because we're in a litigious society, we'll have to sign a lot of documents saying that you understand the market is up and down, and we don't have crystal balls. We're pretty smart. We're not that smart, unfortunately, to predict the future.
All right.
So, anyways, these are all the things that are boilerplated into the contract that will convey automatically with the house if they do exist. So you don't have to worry about getting really specific on writing down certain things that a house will come with.
Okay, so I saw that they had a central vacuum, but I never saw the hose and all the attachments. So do we have to tell them we want to make sure those are there, or how do you do that?
We don't. We could, just to be over the top, cautious, but that all the parts that come with the central vac, like right here, the hose and the bib, and it says attachments right here, all will come with it.
Okay.
Everything. So
because I hate to just move in and see that some of these things that are supposed to be there aren't there. What kind of recourse do I have?
Yep. Well, if that happens, then you do have we do have the ability to get an attorney and go that route. But you'll see there's also a provision in the contract where you have to go through mediation or arbitration first, potentially, for disagreements. But you do have recourse if they do not live up to for potentially specific performance, things of that nature. They don't live up to certain guidelines of the contract.
Was there time? I don't know if it says this in here where we can actually walk through before it closes, just to kind of double check all these.
Yeah, it's later in the contract. Absolutely,
Okay.
We'll do a final walkthrough before we close to check all that. You bet. So we'll initial at the bottom here at the very end. Page 2, some more additional items that come with the property automatically. Okay. Now, if there's anything else that's additional personal property, like if you want their dining room set or their outdoor patio furniture, we could put it in here. But we talked about you didn't really want anything else, so we just put the fridge, washer, and dryer to convey. And they weren't telling us it comes with it, but we're going to ask for it as a point of negotiations. Okay. In this case, there's no other fixtures, lease items as well included with the sale. So Section 2, financing. Okay, so we do have a pre-qualification form from your lender that is attached. We'll submit that with the contract. Now, this is very important right here. Okay, this is one of your 3 contingencies. Okay, that I talked about that you have to get out of the contract if you so choose. This is the unfulfilled loan contingency. What this states, again, it's very buyer-friendly, is that at any point up to 3 days prior to close of escrow, okay, the closing date, if you have to withdraw because your loan program that you're currently pre-qualified for, you no longer are qualified for, the most common example is if you lose your job, you get laid off, then you can withdraw and receive all your earnest money back 3 days prior to closing.
That's good to know.
It's pretty lenient, right?
Yeah.
So that's pretty good. Now, a lot of times sellers may counter that. So don't be surprised if they see a counteroffer with that verbiage saying they want to move that up a little bit, because 3 days is very buyer friendly to us.
You'll let me know.
Well, yeah, absolutely, absolutely. But we're going to leave this in here. We're not going to say anything because that's great for us.
Okay.
Then obviously interest rates, necessary funds, loan status update. This is all things that we'll do for you, obviously through your lender, and make sure the seller is aware of any updates to your loan status. Loan application, you've already filled that out with your lender, from what I understand. Yeah. Loan processing during the escrow, and then time of financing. You're getting conventional here, so that box is checked. Okay.
All right.
Loan costs, you're not asking for any closing costs in this offer. You're going to pay your closing costs yourself at closing, according to what you and your lender decide to do. So we're not going to ask for any concessions right here from the seller.
Okay.
Okay, none of that right there. So that'll all be blank and blank.
Okay.
Changes, that's the part I was telling you about right here.
Oh, yeah.
If you want to change your down payment, for example, we do have to notify in writing the other, and I'll do that for you, the seller. But again, they can't stop you from doing it as long as it doesn't harm them in any way.
Why does it matter as long as they're getting the actual price of the house?
It really doesn't. That's why they can't stop you, but they still have to be aware of it. I guess for probably legal action if they want to do something litigious if you do breach contract after your change, maybe. I'm not sure.
That's kind of weird.
It is kind of weird. I can't really explain that one, but unfortunately I did not go to law school, or maybe fortunately. So, but anyways, appraisal contingency. This is the second of 3 contingencies that you have in the contract, okay? This states that the house does not appraise, okay, for the amount that we're offering, which I can't see happening because we're offering a pretty aggressive amount. But if it doesn't, for some reason, you have the ability to ask the seller to come down to meet that appraised value and move forward, or to withdraw and take your money back, and it's completely refundable at that point.
Can he ask me to go up?
No, I cannot ask you to go up.
Okay, that's good.
Okay, but we do have to let them know the buyer has 5 days, okay, after notice of the appraised value to cancel the contract, or if the seller refuses to come down. Okay, so we'll have 5 days after receipt of that to really make our decision. But again, we'll keep track of all those timelines for you. Appraisal fees. The appraisal fees are not included in seller concessions. We're not asking for any of that. Okay, and it is very standard in Arizona that the buyer does pay for their own appraisal.
Okay.
Okay. So unless you want to get really kind of out of the ordinary, unique with the offer, we'll keep it as such.
Okay.
Okay, and that'll be about $450, maybe $500, somewhere in there.
Okay.
All right, title company. This is Stewart Title. This is a company that we like to use. We use them all the time. Use them for over, I think, 8 years now. The reason we do it is for two reasons. We know the fees are as good as they are out there, okay? So that benefits you and customer service. We know what to expect. There's some bad, we've had some bad experiences with other title companies in the past, and if for some reason there's a discrepancy on maybe a fee or anything of that nature, because of our relationship with them, they'll make sure they take care of it and just treat you top notch, okay? So we definitely know what to expect working with them. Okay, title commitment and title insurance, additional instructions. Now this section right here talks about just that, title insurance. You're getting financing, okay? So your lender will require you to get an Alt-A lender title policy, meaning that you don't really have a choice because they want to insure their interest and there's no liens against the title, okay? And that they're always going to be in first position, okay, on their lien, because that's what they're doing. Does that make sense?
Yeah.
Okay. So if you're paying cash, you might have the option to say, I don't really even pay for it, but because you don't have a choice, and you have title insurance on your policy there, on your property. Tax prorations, obviously your property taxes will start the day you close and be prorated as such, and they're paid in arrears in the state of Arizona. Release of earnest money. This talks about if there's a dispute, the breaching party, let's say for example, we breached the contract and we're outside of our timelines, which will not happen, guarantee will not happen, but if we did, then the money will be released to the party who wins that dispute, okay? Yeah, I know. I know. That's our number one thing. Not only will I be tracking it, but our transaction coordinator tracks it. So you have basically 4 eyes on the contract at all times, watching that calendar. Okay. Assessment liens. If there are any other assessments, okay, other than the homeowners association assessments, that is a lien as of the close of escrow, it shall be the responsibility of the seller. You do not have to pay any of that stuff. Okay.
Good, yeah.
Which is very important. IRS and FERPTA, you do not have to worry about that because you're not a foreign person. So we'll switch that one. Next page, seller property disclosure statements, otherwise known as the SPUDs. That's what we call them. You'll see these a lot. Now, per the contract, the seller has 5 days to deliver these, okay, to us, to review during our 10-day home inspection period. So that if there's something you don't like in there, we have the ability to withdraw.
Okay.
Does that make sense?
Yeah.
Okay. And then insurance.
Can we ask them questions about it?
Absolutely,
Okay.
absolutely. They should explain most of the stuff, but we can definitely ask them questions too. The insurance claims history report. Okay, they have to also provide us a letter from their insurance provider stating that they had any claims against the house during the time they've lived there.
Okay.
Which is good to know, very good to know. So we'll get that as well to review. Lead-based paint disclosure. This house was built after 1978, so we don't have to worry about that. Affidavit disclosure. That's not applicable in this situation because you're not in an unincorporated area. You're actually in a city or town. Changes during escrow. Again, if the seller changes anything from this standpoint, they would have to notify us as well in writing too. So anytime any party wants to change anything, they have to notify the party so they're aware of it.
Like what would they change?
Well, for example, this reads here, like any disclosures. Like, let's say they want to update their disclosures because they forgot something, or maybe during the time it's on the contract, the roof started leaking and they had it fixed. Something new that they didn't know about prior to just happened. They have to notify that up. They can't just say, "Oh, sorry, it just happened."
Good.
Yeah.
That's
so it's
helpful.
very good to know. Okay, this part's important here. Warranties, seller warranties, and buyer warranties. Seller warranties. So there are certain items, okay, when we do our inspection after this contract is accepted, that by signing this contract, the seller is already agreeing to fix those items if they are not in working condition. Pretty cool for the buyer.
Yeah.
Things like mechanical issues. It talks right here: swimming pool, electrical, plumbing, heating, cooling, freestanding range oven, built-in appliances. Things of that nature have to be fixed if they're not in working condition, which is, again, great for the buyer. Okay. A lot of sellers don't get educated on this. They don't realize that by signing this contract agreement, they have to make sure these items are working order and condition. So, also too, the buyer warranties. Buyer warrants and that buyer has disclosed to the seller any information that may materially or adversely affect the buyer's ability to close or complete the obligations of the contract. In other words, if you know you're going to quit your job in 2 weeks, and there's some sort of, they can prove that somehow, where you would not be able to get financing for the house potentially, or puts that loan in jeopardy, then you have to disclose that, okay? But I don't think you have anything to disclose like that, do you?
No,
or do you?
But what is this, warranties that survive closing? What does that mean?
Good question. Seller warrants that seller has disclosed to the buyer and brokers all material latent defects and any information concerning the premises known to seller, excluding opinions of value which material adversely affect the consideration to be paid for by buyer prior to close of escrow. So seller also warrants that payment in full will have been made for all labor, professional services,